Get married like the curves, different Aisha shit. We more like Betty, Tommy, and Keisha shit. Yeah, you, CLC, you wanna creep and shit. Poured out my whole heart to a piece of shit. Man, I thought you would've learned your lesson. Wow, liking pictures, not returning text. I guess it's fine, man, I get the message. You still stutter after certain questions. You keep it calm, that with certain answers. Do you know? Trust me, nigga, it's cool though. Steady two was working, but she out here chasing polo and putas to the pool side, living two lives. I just did what you did to me to you a few times, but if I did decide to slide, find a nigga, fuck him, suck his dick, you would up and piss. But that's not my MO. I'm not that type of bitch. The karma for you is gonna be who you end up with. Don't make me sick because I thought I gave you everything was mine is yours. I want you to live your life, of course, but I hope you get what you died for. You care for me. Do you know what you're doing? Who feels that you hurting and bruising? You gon' get your whole world, but it's big. But the girl that you lose and be careful with. Yeah, it's not a threat, it's a warning. Be careful with. Yeah, my heart is like a package, but fragile. You want it, be careful with me. Carefully. Always say that you be carefully. Oh, you better treat me carefully. I was here before all of this. Guess you acting out now, you got an audience. Tell me where your mind is, drop a pin, what's the coordinates? You might have a fortune, but you lose me, you still gonna be misfortunate, nigga. Some, it's blood shots, so just fucked up in the head. You want some random bitch up in your bed. She don't even know your middle name. Why? Because she might steal your chain. You don't want someone who love you instead. I guess not thoughts, blame disrespect. Nothing like the nigga I met. So sweet, crazy, and you're quick to forget. You ain't got me tripping. You got me looking in the mirror different. Thinking I'm wrong because you ain't the difference between them. Rocking a hard place, the mud and the dirt. It's wrong. Hurt me to hate you, but loving is worse. It all stops so abrupt. Started switching it up. Teach me to be like you, so I can not give a fuck. Free to mess with someone else, but when these feelings come out, if you don't care about a thing, it's such a motherfucking self. Every man, I thought I gave you everything was mine is yours. I want you to live your life, of course, but I hope you get what you died for. Be careful on me. Do you know what you're doing? Who feels that you hurt and bruising? You won't get the whole world, but it's big. But the girl that you lose and be careful with.
Right, y'all. Welcome, 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 welcome to the stream. Hey, y'all. How y'all doing? Now, I am going to jump right into this, trying to make it just really quick, brief, and to the point. Um, there are quite a few updates going on in this case of the state of Florida versus Citizen, aka Justice Senior Doe. This, hold on a second before I get started. Hold on, let me see if I have it here. Hold on. Nope, I don't. I don't think so. Hold on. Hell no, I don't. I guess not. Well, I was gonna try to hit y'all with the disclaimer, but I'm gonna just say that this live stream is being done for educational purposes, commentary, and criticism, and also everything that I'm sharing during this live stream are all factual. There's nothing made up. It's it's actually regarding a active legal case, and I'm providing you guys with a accurate update on the status of said case. Now, I'm gonna go ahead and jump into it. I am going down the docket, and I'm starting with. Oh, before I jump into it, let me check my sound real quick. I want to make sure I sound okay. Hold on, y'all. Let me just check. Okay, yeah, I sound fine. Good. So on January 19th, I'm starting with January 19th, 2026. Citizen has gotten an attorney. He retained an attorney, as he should. This is a very serious case, and unlike the civil matter, he in which he represented himself, which I'm also going to be providing you guys an update with, hopefully by next week. But he, I think he realized that he could not represent himself on this in this case. So on January 19, 2026. His attorney filed a motion for bond modification and return of a phone. And the motion reads as follows. Comes now the defendant by and through his undersigned counsel and moves this court to modify his bond conditions and additionally to order the Escambia County Sheriff's Department to return a phone seized from the defendant and has grounds, therefore, states as follows. Number one, the defendant was arrested on January 9th, 2026. Pause. That is incorrect. He was arrested on January 6th, 2026. But let's continue. On the charges of count one, aggravated stalking, count two, violation of court ordered injunction, and count three, criminal solicitation. Number two, at the time of his arrest, officers for the Escambia County Sheriff's Department conducted a search based upon a search warrant that resulted in the seizure of several communication devices owned by the defendant, including a cell phone described as a black iPhone with case. The phone number for this cell phone is 85022, and I redacted the rest of the number to ensure that he does not get nuisance calls, unnecessary, people stalking and harassing him, because that's not what we do over here. Number three, the defendant earns his income from being an influencer on the social media site known as Beagle Live, as well as earns income through his business, which is named Official Citizen Talent LLC, from other social media sites. The nature of the business operations for all social media sites are lawful, and the defendant is not accused of engaging in any unlawful acts based on the type of business activities conducted by the defendant for income. Now, I'm going to stop right there real quick because that would be an incorrect statement. The charges here that are listed, count one, aggravated stalking, and I think the full charge has cyber stalking attached to it. The full charging on the in the charging document. It says cyber stalking. So I don't know how his attorney can make this argument that his business dealings have nothing to do with the charges itself. But anyways, I digress. Let's continue. Number four, the defendant's first appearance after his arrest took place before County Judge Lytle. Judge Lytle's um, pre-trial release order provided that the defendant could not use the internet, nor could he go on any social media sites. The defendant asserts that this order by Judge Lytle was overbroad and therefore violative of the defendant's constitutional rights under the First and Fifth Amendment of the United States Constitution, as well as Article 1, Section 2 and 4 of the Constitution of the state of Florida. Number five, The defendant is being deprived of access to his business operations and his financial accounts because of the current court order. The defendant is the father of three minor children for whom he provides food and shelter. Pause. The food's part, the food, I can understand that. I can totally get that. I can dig that. But the shelter side of it, like, is Citizen a single father now, y'all? Because last time I checked, he still has an active child support order in the same court. The same court actually manages his child support order, his child support cases. So, like, I don't know, his attorney, he trying it. His try A for effort. I'll give his attorney an A for effort. Let me just say that. I'll give his attorney an A for effort. Let's continue. The defendant and his family will soon be destitute without relief from the court. Number six, the defendant submits that the court should modify his bond conditions to address any concerns by the state regarding the safety and well being of the alleged victim and the community in a narrower fashion than that which is currently in effect. The defendant submits such reasonable safeguards can be fashioned. Number seven, the defendant requires access to the cell phone referred to above in order to conduct his business operations. The defendant submits that the return of the cell phone to the defendant will not prejudice or interfere with the collection of evidence by the Escambia County Sheriff's Department because the ability to download all information from the phone for the purpose of review or and preservation. Wherefore, the defendant the defendant prays this court modify his bond conditions and orders the Escambia County Sheriff's Department to return a phone seized from the defendant. Okay, so just to kind of put it into you know, one sentence, he trying to get his phone back. He acting like he a single daddy, and he not. And he acting like the cyber stalking charge doesn't exist, but it does. So I don't know how he figured he could get a phone back that is actually the tool, like what he used to get on the app to stalk and harass the alleged victim. But anywho, let's go. The next one that I want to go over with you guys is dated January 22nd, 2026. It is a notice of defendant's intent to participate in discovery. Now, I'm not going to be reading that document because, I mean, it's self explanatory, really, guys. If you are a defendant in a criminal proceeding or even a civil matter, you have the right to be included and very much involved in the discovery phase of your case. Discovery is basically the evidence that the state plans to present at trial. During any court case, whether it be civil or criminal, any evidence that is had by both sides has to be shared with the other. There are to be no surprises at trial. And we all know that Nature Boy was also involved in his discovery process, right? That he did get all of the discovery because y'all remember Team Too Much created a whole video, the what was it? The malicious prostitution video. So we know that they had all the evidence too, but that didn't change his outcome. So again, it is standard practice that the defendant be involved in discovery. The next item is dated 1/22/2026. It is the PTR agreement, and it reads, and this is a form that he signed upon release and upon meeting with pretrial services. It says, I have been released from the Escambia County Jail to pretrial services program for pretrial release, PTR, under the following. Number one, I agree to obey all federal, state, and local laws. Number two, I will appear in court as ordered. I understand that it is my responsibility to keep track of my court dates and stay in contact with my attorney or public defender. I will contact my pretrial services officer each court appearance to inform him or her of the progress of my case. Number three, I will report to my pre-trial services officer weekly in person every Tuesday starting January 20th at the pre-trial services office located at, and they provide the address. However, I redacted that. What I will say is it's in Pensacola, Florida, between the hours of 8 a.m. to 4 p.m. And then they provide the office number as well as the fax number. It says weekly check-ins will cease when my case is disposed. I will not possess I will not possess or use any type of illegal drug. I will not consume alcoholic beverages while on pretrial services. I agree to submit to random drug and alcohol testing at my expense. Urinalysis is $29. A breathalyzer is $15. It is payable by credit card or debit card or money order only. Um, I will not carry on my person or have in my possession any weapon or pum while on pretrial services. I agree not to travel beyond 100 miles from my residence or change my residence without first obtaining permission from my pretrial services officer. I will allow my pretrial service officer to visit my home and employment site if necessary. I agree to the following special conditions as ordered by the court, and I will comply with all instructions of the court and pretrial services. Number one, active GPS prior active GPS monitor prior to release. Number two, the victim was given 48 hours to pick up a pager or monitor is removed. And I'm going to go back to that pager in a second, guys. Number three, no social media. Number four, abide by domestic violence injunction. Number five, I think it's five. Am I? Okay, whatever. I'm going to stop saying the number, y'all. No weapons or fumes surrendered. All weapons or fumes should be surrendered to the sheriff's office within 24 hours of release. Stay away 1,000 feet from the alleged victim's residence and place of employment. No contact with the alleged victim, and no internet usage. Now, let me go back to that. Victim has 48 hours to pick up pager or monitor is removed. So, Holly was given 48 hours to go down to the pretrial services office to pick up a pager. That pager is a tracking device. Should citizen, aka Justice Senior Doe, be within 1,000 feet of her person, that pager is going to go off. She is going to get an alert. So will the folks at pretrial services. They will receive an alert. And if it is found that he is within that proximity, and I'm sure he'll be notified as well, he will need to get out of that area immediately. Okay? So, like if she's at Publix and he is across the parking lot and that thing goes off and his ankle monitor beep, 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 he got to get up out of there ASAP. Okay? Technology is something else. And then it says, I certify that the information provided during my pretrial services interview is correct and accurate to the best of my knowledge, and I gave my permission to the Escambia County Pretrial Services Program to investigate this information in any way necessary. I also agree to sign a waiver of confidentiality if necessary. Additionally, I certify that I have read and fully understand the above conditions of release, and I understand that any violation of these conditions will result in this bond being revoked and a warrant for my arrest be put out against me. I agree to abide by these conditions of I agree to abide by these conditions of pretrial services until the case pending against me is disposed of by the court. So this was actually signed on January 12th, 2026, but it's actually kind of like, docketed at a different time, placed on the public record. Now, I just want to say real quick that third party contact and third party harassment is still continuing. It's still happening. And all I'm going to say about that is y'all keep watching. Keep watching. Because it's about to get real interesting. This thing right here about to get real interesting in a minute. Just let it cook, okay? Let it cook. Remember I said it here first. Let it cook. You know, just we gonna let it burn, all right? Now, January 23rd, 2026, his attorney resubmitted the motion for bond. Now, why did he resubmit it, right? Because it's the exact same motion that I read at the beginning of this live. According to my research, there's several common reasons. It could be a procedural thing. Maybe the motion was filed in the wrong division or incorrectly labeled. In such a case, the defense counsel would just refile and resubmit it, right? Um, the state attorney formally objected to this motion. They notified him, the attorney, that they affirmatively object. So I'm believing that the resubmission is to urge or ask the court, basically the judge, to go ahead and move forward with the modification and to return the phone. Now, it is going to be up to the judge to decide at this point. And I believe, if I'm not mistaken, a hearing has been scheduled on that. I want to say it's the 16th or the 17th of February that's coming up. I will keep you guys posted on that. But the judge will most definitely take the state's objection and their position on the modification into consideration while making his or her ruling on the motion. So again, I'll keep you guys posted on that. As soon as I know, you guys will know. Now, this next document, it's actually dated January 17th. However, it was docketed on the 29th of January. Okay. So I identify each document by the docketed date simply because prior to that date, it wasn't, public information. Okay. So on January 29th, 2026, a demand for alibi was submitted to the defendant. Okay, so I'm going to read this document in its entirety to you, and then I'm going to give you a little bit of an explanation as to what this means. Pursuant to Rule 3.200, Florida Rules of Criminal Procedure, the undersigned state attorney hereby makes written demand upon you, the said defendant, within the times and in the manner prescribed in said rule, to file and serve upon such state assistant state attorneys notice in writing of your intention to claim or offer evidence of any alibi in your defense in the above mentioned case, which notice shall contain specific information as to the place at which you claim to have been at the time of the alleged offense in said case, and as particularly as is known to you or your attorney, the names and addresses of witnesses by whom you propose to establish such alibi. Then it's signed and it says, this hereby informs you, as particularly as is known to and said prosecuting attorney, that it is alleged that said crime charged against you in said case is committed in at or in Escambia County, Florida, on or about the date, place, and time indicated on the probable cause affidavit filed with the court clerk. Failure to comply with this demand subjects you to certain penalties provided for in said rule. So they're referring back to the rule that they cited at the beginning, which was Rule 3.200. And is hereby certified and sworn copy and signed electronically by this assistant state attorney. Now, what does it mean? So, in Escambia County, and actually just anywhere else in Florida, a demand for an alibi is a formal request in a criminal case from the prosecutor under Florida Rule of Criminal Procedure 3.200. It's not unique to Escambia County, but it is a part of the statewide procedure for handling an alibi defense. Okay, so basically, the prosecution is asking citizen if he has an alibi for the allegations being made against him. Um, the state and also like the federal government, if this was a federal case, they have to go ahead and lock in any potential alibi defense that a defendant might pose so that they can actually go ahead and investigate it, confirm it, or dismiss it, or what have you. So this is what this is demand for alibi is about. And again, this is procedural. It's normal in a criminal case. The next document that I want to go over with you is the most interesting. Let me see if my likes are liking real quick. How y'all doing in the chat, by the way? How y'all doing in the chat? Y'all good? Don't come up in here acting a fool now. My mind squad be on it. They don't play no games. They don't play no games with folks. Ain't no trolling over here. Ain't no trolling over here. The mind squads, trigger fingers be heavy. Oh, she's lucky she's not involved in the case. BGF. How you know she's not involved? How do you know? How do you know? How do you know? Don't trust your feelings. How do you know? How do you know? Looks be deceiving. How do you know? How do you know? Let me tell y'all something. When it comes to when it comes to when it comes to the judicial system, they do not have to share everything up front. I None of us knew if you were following Nature Boy's case. Nobody knew that Nature Boy sat down and talked to the police for 45 plus minutes and confessed. in that 45 plus minute conversation to them? Nobody knew that until they played it in court. Did nobody know that? No one. So I would just say keep watching, pay close attention. If you're not already subscribed to the channel, consider subscribing today. Be sure to set your notifications to all so that you're notified when I go live or add new content. Okay? Okay. Now, the next charge, the next charge is the no prosecution with no prosecution with charges. Now, the criminal solicitation burglary felony of the third degree. That charge is the charge that they are referencing. I have heard people on Beyonce's internet saying that, oh, his charges were dropped. Oh, this shows that it's a weak case. This show, look, they already dropping charges. Oh, it's just blah 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 blah. Like, like it's like I'm like, are you? Do you read? Do you research? Do you pay attention? Like I pray to God nothing ever happened to you legally, or like your family members, because y'all don't the fuck. But anyways, I digress. And it reads: the office of the state attorney in and for the first judicial circuit of Florida announces a no prosecution on criminal solicitation burglary felony of third degree. The defendant was arrested on January 6, 2026, for the following reasons combined. Pay attention to the word combined, okay? The office of the state attorney in and for the first judicial circuit will be proceeding on the following charges. Number one, aggravated stalking by violating injunction or court order. Number two, solicitation of aggravated stalking by violating injunction or court order. Number three, violation of injunction against dating violence dated January 29th, 2026 by this, I'm just going to say, Assistant State Attorney Burns. Now, what the state just did, I'm going to explain what they just did. Okay. The state attorney is dropping the charge of criminal solicitation to commit burglary, third degree felony, right? That specific charge is basically gone and is dead for now. Key part of what I just said is for now. There's no trial on it. There shall be no plea given, like don't, plea and offer given on it. There's no conviction to be had on that. That count is pretty much irrelevant at this moment for now. Now, why it says for the following reasons combined. Combined means the prosecutors decided that the conduct underlaying the burglary solicitation charge is being folded into other charges they are continuing with. In other words, they're not saying the conduct didn't happen. They they are saying it will be addressed through other more appropriate or stronger charges. This is a very common procedural move to avoid duplicative charges, to streamline a case, and also to focus on charges with cleaner elements and higher penalties. Now, what the state is still prosecuting, the case is very much alive on these charges: the aggravated stalking, the solicitation of aggravated stalking, the violation of an injunction against dating violence. Those are serious charges, especially aggravated stalking tied to an injunction. Why this matters legally? I'm going to tell y'all why it matters legally. Aggravated stalking plus solicitation plus injunction violations often carry stronger evidentiary footing than, you know, a burglary based solicitation. It's a better match for the alleged behavior: harassment, threats, third party contact, continued conduct. Okay. Um, can I just say it again real quick? Like the third party contact and the continued conduct. I'm gonna say it one more time for good measure. Let me say it three times, y'all. Third party contact, continued conduct. All right, clock it. And it also will allow the state to tell a cleaner narrative to a judge or jury. So instead of arguing they solicited someone to commit a burglary, the state is saying they repeatedly violated a court order, stalked the victim, and solicited others to help do that. Okay? That's often more compelling and easier to prove. All right? So, the importance of the no prosecution is this is not an acquittal of that charge. It's not a finding of innocence, and it's not a dismissal without prejudice. So the state can actually they could bring that charge back if they want to, if they really want to. But in this case, I don't think they will, because again, it's being folded into a a different charge, a different, statute level, which is stronger and carries higher penalties. So I hope that that clears up the little ticker tape parade and party that everybody's been having on Beyonce's internet, because Sugar Honey Iced Tea just got real when they dropped that charge and replaced it with another higher penalty phase charge. It's like, what the fuck? Like, bro, you have to. Okay. Now, the next thing that I want to share with you guys is dated also January 29th, 2026. Now that we understand what happened with that one charge, let's talk about the certificate of cancellation of bond. There was a document sent to the bonding company, any our bail bonds. The amount, and it states the bond amount for the one charge was $5,000. And the notice sent states this is to certify that on or about January 29th, 2026, the bond with the above power number was canceled by reason of the following disposition: no pros. That means no prosecution. And then the person rendering the decision is the Honorable Judge Broderson. Yeah, Broderson. Okay, so she signs and seals that. This is standard process. If you have a bond and you have like 5 counts and they actually Like in this case, say they're not going to prosecute on that charge, but then fold it into another charge. If that happens, hold on, turn on restrictions. What? Turn on restrictions. Use hand gestures to send reactions. Blah 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 blah. What the frick? I don't know what just happened. Something just popped up on the screen. I'm like, what the hell? But basically, it's procedural. You know, they have to notify the bonding company if they adjust anything as it relates to the charges that impact the bond directly. It is appropriate and correct housekeeping measures because the courts have to notify the bonding company so that they have an accurate account of how much money you owe them and things of that nature. So that's just the normal process. So I just wanted to put that out there because there was also like some type of mass celebration and hysteria about basically the court doing the right thing. This is what they have to do. They have to keep accurate records. It's not like they can not prosecute on that one charge that actually generated a bond amount for him and not tell the bonding company. So they notified them and they actually let them know which charges they were going to continue on with. And then, let's see, let me go. I lost my space because of that damn whatever's popped up on the screen. Let me go. Scroll, scroll, scroll. Hold on, y'all. Uno momento, por favor. All right, so let's continue. This is standard, blah, blah, blah. Okay. Now, lastly, I want to go over, I want to read to you the information. But before I do that, I want to explain to you what the information is in legal terms, like what it means. Okay. Now, in the state of Florida, in a criminal case, the information has a very specific meaning. It's not just general information, it's a formal charging document. What the information is, an information is an official document filed by the state attorney that formally charges a defendant with crimes. Once an information is filed, the case moves from the arrest phase into the formal prosecution phase. In Florida, most felony cases are charged by information, not a grand jury indictment. So, like, Nature Boy got indicted in Georgia. His case was brought before a grand jury. If I'm not mistaken, they had an indictment. It wasn't just based on information because I remember, I think I have the indictment in my files. Diddy. Diddy was indicted by the federal government. They brought his case in front of a grand jury, and the grand jury said, yes, go ahead and arrest him. In the state of Florida, it works a lot differently, where the information that I'm about to share with you that was filed on the 29th of January is technically an indictment. It's a formal notice to let the defendant and his counsel know that, yes, we are moving forward with prosecution on these charges. So the information will list the exact charges the state is pursuing. It will cite statutes of the law that were allegedly violated. It'll also describe some essential facts as it relates to each charge, and it also will lock in the defendant's what the defendant must defend against in court. Okay. Now, why does it matter? Why does it matter, y'all? It matters because this is a big procedural step. Before the information, the person may be arrested or jailed, but the state is still deciding whether or not they want to prosecute. Once the information is filed, the case is officially moving forward. The defendant is arraigned, discovery begins, motions, hearings, and trial scheduling will follow. So now that that's out the way, let's get to the information. Y'all, please be sure to hit that like button, tap in, tap in. Go ahead and hit that like button. Hit me one time with that like button if you just get in here. Thank you for being here. Um, I know a lot of people don't really like the, regular facts without the razzle dazzle, the cupcake sprinkles, and all that other sugar honey iced tea. But when I'm talking about the legal document, the legal paperwork, I want to make sure that I'm, just giving it to you straight, no chaser, because this is important. This is an opportunity for all of us to learn more about the judicial system. And I have an announcement to make at the end of this, by the way. Now, he filed on January 29, 2026 at 9:14 a.m. They listed in the information the date of the arrest as January 6, 2026, which is correct. They also listed the defendant's full legal name as well as some identifiers of the defendant, such as his race, his sex, and his date of birth, just to identify him, as well as the charges. Number one, aggravated stalking by violating injunction or court order. Number two, solicitation of aggravated stalking by violating court order. Number three, violation of injunction against dating violence. Okay. In the name and by the authority of the state of Florida, in the Circuit Court of Escambia County, Florida, state of Florida, the plaintiff, and they list his full legal name here, citizen, as the defendant. A ASA, which is Assistant State Attorney, I'm just going to say her last name, Madden, for the First Judicial Circuit of Florida, prosecuting for the state of Florida, charges that citizen between January 29, 2025 and December 10th, 2025, at and in Escambia County, Florida, after an injunction for protection against repeat violence, sexual violence, or dating violence pursuant to Section 784.046 Florida statutes, or on or an injunction for protection against domestic violence pursuant to Section yada 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 Florida statute, or after any other court imposed prohibition of of conduct towards the alleged victim or her property, did willingly, knowingly, and maliciously and repeatedly follow, harass, or cyberstalk another person in violation of Section 784.0484 Florida statute. Then they put count two, and your informant, after said prosecuting, as after said on her oath, after said therefore information makes that citizen between January 29th, 2025 and December 10th, 2025 at and in Escambia County, Florida, after an injunction for protection against repeat violence, sexual violence, or dating violence. Again, they repeat the property part and did solicit by commanding, encouraging, hiring, or requesting James Earl Dixon and or Nicholas Wallace to unlawfully, knowingly, willingly, maliciously, and repeatedly follow, harass, or cyber stalk another person. Now, I just want to make sure that you guys know James Earl Dixon's name on Vigo is Dixon, and Nicholas Wallace is Ace on Vigo, so that we know who those people are. Count three, the same. She says the same. And your informant. And just so you guys know, when I say and your informant, I'm not talking about like an informant just yet. I'm not saying that they have a witness to inform upon activities. What in this instance, when I say informant, this is referring back to the SA, the ASA, the Assistant State Attorney. That's just how they write this legal document up. Okay. And after said, it's basically just referring back to her. So I just want to make sure that that's clear. Okay. But keep watching because that informant part. Ooh, child. Okay. All right. And they have count three in there as well. I'm gonna skip through. But long story short, they're laying out all of the charges that are being brought against him and put it in, putting some pen to pad and paper to let it be known that this is what it is. You're going to be prosecuted for this, this, and that. Now, the possible consequences, which I didn't go over on my Bigo live stream, but I'll go over here with you guys. Number one, the aggravated stalking by violating an injunction or court order. It's the classification is a felony of the third degree, and there are possible penalties of up to 5 years in Florida State Prison, up to 5 years of probation instead of prison is possible, up to a $5,000 fine. There, these are like the general third degree felony penalties under Florida law. And if y'all are interested in looking it up, the Florida statute would be 775.082. The next one is 775.083. And the next one is 775.084. Additional court orders may be imposed, including a long-term no contact or protective order, sometimes years. Restitution. I'm going to say restitution like 5 times right here. Restitution, 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 restitution. Y'all just keep watching. That's all I'm going to say. Treatment programs. For example, counseling. These are dependent on the judge's discretion and the facts of the case. The solicitation of aggravated stalking by violating the injunction or court order. This charge is typically treated as a third degree felony as well, because solicitation of a felony is um, is punished at the same level as the crime solicited, unless a different statute charges that. So if someone is convicted of solicitation of aggravated stalking, the classification is likely going to be a felony of the third degree. Possible penalties are the same as the aggravated stalking charge that I just read to you. Up to 5 years in prison, um, 5 years probation, $5,000 fines. So the solicitation doesn't add extra statutory penalties beyond the underlying offenses level unless the statute says otherwise. And here it kind of mirrors, it just mirrors the aggravated stalking. Now, the violation of the injunction against dating violence under Florida statute 784.047. First conviction, the classification is a misdemeanor of the first degree. Possible penalties up to 1 year in county jail and up to $1,000 in fines. Enhanced. Multiple prior convictions. If a person has two or more violations of injunctions, protection orders, and then violates again, it gets upgraded to a felony. Okay. Now, in real life, this could mean, long-term probate, jail time, um, long-term protective orders put in place by the judge, um, probation with conditions, of course, criminal record, because felony convictions on a person's record permanently, it can, definitely be a problematic as far as, people ruining your background and all of that. Collateral consequences. These, if convicted, can, include loss of cum rights, employment issues, immigration consequences. For non-citizens, it can be a serious problem. Difficulty securing housing or a professional license. So that is my overview and update on the goings ons with the goings ons. And let me see, what time is it? Yeah, we did good. We right at an hour, guys. That was perfect. That was perfect. And I'm sorry I haven't been paying attention to the comments. I like dip in here and there, tiptoe here and there. Can we get the lights up a little bit, y'all? But I wanted to make sure that I went ahead and, you know, put a complete update here on my channel because I don't know if anybody recorded my Beagle live stream and posted it anywhere, but or if they just recorded it just to have it and, I don't know, listen to it. I don't know. I have no idea. So, and I haven't seen it posted anywhere. So I was like, let me go ahead and make sure that I get this word out to the people, get the word out to y'all so that y'all know what's happening, what's happening, you know. Let me see. Is this playing it yet? What the hell? Okay, there we go. But yes. So that is the update, guys. Anybody have any questions? Any questions in the comments? I'm gonna go ahead and look at y'all comments real quick before I get up out of here.
It's like the morning time. Don't wanna wake up back. Just wanna stay in bed. But if I'm next to you, I'm looking forward to just laying in this bed. Oh, that never gets old. I'm sure never let it go. I don't want no one else. So we should be chilling today. Ain't nothing wrong with that. So tell me that, tell me that. Tell me I'm the best I am. I'll be feeling like yes I am. You know I'm the best I am. More than I take me as I am. Tell me I'm the best I am. I'll be feeling like yes I am. You know I'm the best I am. Oh, and I'm taking inside. You're like the sweetest thing I know, like my favorite love song. I need you really bad. Don't take it for granted, you'll be regretting it. Oh, I should be your last. Oh, yeah. Oh, that never gets old. I'm sure never let go. I say it brings me somewhere. So we should be chillin'. Ain't nothing wrong with that. So tell me that, tell me you're the best I am. I'll be feeling like yes I am. You know I'm the best I am. All I take yes I am. Tell me I'm the best I am. I'll be feeling like yes I am. You know I'm the best I am. All I take yes I
All right, y'all. I'm about to get up out of here. I will see you guys very soon. I'll catch you on the next one. Y'all have a wonderful night. Well, morning, afternoon, or night, based on wherever you're tuning in from. I'll catch you later.